In a swift legislative move that has redefined the roadmap for Nigeria's 2027 general elections, President Bola Tinubu has officially signed the Electoral Act Amendment Bill 2026 into law. The assent comes at a time of heightened political tension and follows a period of intense deliberation within the National Assembly. While the government maintains the new law is a milestone for transparency, civil rights advocates and opposition figures are raising alarms over specific clauses they claim could undermine the sanctity of the ballot. With the Federal Capital Territory elections serving as the immediate testing ground, Nigeria stands at a critical crossroads regarding its democratic integrity. What happened? The core facts. The journey of the 2026 amendment was characterized by its unprecedented speed. On February 17, 2026, the National Assembly passed the final harmonized version of the bill. Within 24 hours, the document moved from the clerk's office to the presidency, receiving executive assent on February 18th. This rapid progression stands in contrast to the 2022 Electoral Act, which underwent years of revisions and was rejected multiple times by the previous administration before eventually becoming law. The 2026 Act was passed despite a visible protest within the Senate, where a minority of 15 senators openly opposed the adoption of the harmonized version, specifically citing concerns over the wording of clauses related to result transmission. The executive branch and legislative leadership have framed the act as a victory for the Nigerian voter. The Senate President has stated that the 2026 reforms are designed to ensure that every vote is accurately counted and accounted for. Proponents within the administration argue that the law provides the necessary legal backing for technological advancement while maintaining a pragmatic fallback system to prevent total electoral collapse in areas with poor infrastructure. Conversely, civil society organizations and human rights advocates view the speed of the signing as an attempt to bypass deep public scrutiny. Critics argue that the minority voice in the National Assembly, though numbered fewer, reflects a significant portion of the electorate that remains skeptical of the government's intentions. Advocacy groups have characterized the legislative process as one that prioritized political expediency over a truly transformative reform that would make electronic transmission of results absolute and mandatory without exception. To understand the current friction, one must look at the evolution of Nigeria's electoral laws over the last decade. The 2022 Electoral Act introduced the bimodal voter accreditation system and the INEC result viewing portal. However, during the 2023 general elections, technical glitches prevented the real-time upload of presidential results, leading to widespread litigation and a decline in public trust. The 2026 amendment sought to address these gaps but introduced a controversial proviso. While Section 60 of the new Act mandates that presiding officers must electronically transmit results from polling units, it also includes a clause allowing for manual results to be used as the primary legal record if electronic transmission fails. Advocates argue this creates a loophole that could be exploited to bypass the IREV portal entirely, effectively returning the collation process to the era of manual manipulation. The implications of this law extend beyond the courtroom. Nigeria is currently battling significant voter apathy. In the 2023 presidential election, only a small fraction of 93 million registered voters participated in the process. When the legal framework for elections is perceived as opaque or easily manipulated, the incentive for citizens to participate diminishes. Furthermore, the Act impacts the logistical and financial preparation for future polls, with a shortened window for the release of election funds, now 6 months instead of 12. There is increased pressure on the Independent National Electoral Commission, INEC, to execute complex procurement and training under tighter deadlines. For the average citizen, the ability to now download and print a permanent voter's card electronically is a positive step towards inclusion, yet this is overshadowed by fears that the final tallying of those votes remains vulnerable. As of today, the Electoral Act 2026 is the law of the land. Its first real-world application is the FCT Area Council elections. This local poll is being watched as a crucial litmus test for how INEC interprets the glitch clause in Section 60.
Observers are monitoring 3 specific areas.
The iRev performance. Will results be uploaded in real time, or will network issues be cited to justify manual collation? Judicial interpretation. How will the courts handle the first wave of petitions filed under this new legal framework? Citizen mobilization. Civil society groups have indicated they will shift from protesting the law to mobilizing and monitoring, focusing on holding the judiciary and the Ministry of Justice accountable for the implementation of the act. The road to 2027 has begun, and while the legal architecture is now set, the credibility of the upcoming elections will depend less on the text of the law and more on the integrity of those tasked with its execution. The 2027 elections will be decided by those who show up. If you found this breakdown helpful, hit the subscribe button and turn on notifications so you never miss a deep dive into the laws that govern Nigeria. Do you think the 24-hour speed of the president's signing was a sign of efficiency or a move to avoid public outcry? We're reading every comment, so let's talk.